I know some people, they have signed something in their lease, like a disclaimer. Is that a thing? Is there some
That's
sort
great.
of,
Because
yeah,
those things are
talk about
out.
those elements, some of these other things that can be barriers or be advantages once you get to this stage. What happens now?
Yeah, so I'm glad you brought that up because I'm seeing the mold disclaimer more and more. And, you know, you sign disclaimers lots of different places. You know, if you go join a gym, they make you sign a waiver that says that you're giving up rights to negligence. And I've signed those before, and then I've told the person behind the desk, you realize this is, you know, totally worthless, right? Because you can't sign away things like that. And mold is one of those things. So they can have you sign whatever you want. I think those are mostly used by the landlords to try to bully people into leaving these sort of claims alone. But the Landlord-Tenant Act's very specific that you can't be asked to sign away the rights that are protected by the Landlord-Tenant Act. So you can't agree, even if you sign a document that says, I agree that this roof doesn't have to be, you know, waterproof. That's not enforceable, and no magistrate's court is going to allow that. And these landlords can actually open themselves up to some liability by trying to have you sign those sort of things. I've not seen that pressed yet, but I would love to see that at some point. You know, just the idea of having you sign a mold disclaimer, running afoul of the Landlord-Tenant Act. So don't be scared off or intimidated by those sort of things. They've still got their obligations under the act.